O'Callahan versus Waller and Beckwith Realty Co. Facts. Miss O'Callahan entered into a lease agreement with Waller and Beckwith Realty that contained an exculpatory clause, a clause that relieved the lessor from any liability to the lessee for personal injuries caused by neglect of the lessor. Later, Miss Callahan slipped and fell on the property due to alleged defective payment. She sued Waller and Beckwith Realty for negligence. Issue. Are exculpatory clauses in a lease of property for business purposes unenforceable for violating public policy? Rule. Exculpatory clauses in a lease of property for business purposes are enforceable and do not violate public policy if the relationship of lessor and lessee has been considered a matter of private concern, not public concern. The exculpatory clause benefits both the lessor and lessee, and the relationship of landlord and tenant does not have the monopolistic characteristics that have characterized some other relations with respect to which exculpatory clauses have been held invalid. Application. Here, the lessor and lessee relationship between Beckwith Realty and O'Callahan was a matter of private concern, not public concern, because the lease was for a personal apartment. Here, the exculpatory clause benefited the lessor because Beckwith Realty was relieved from liability for negligence, and the clause benefited the lessee because such an agreement transfers the risk of a possible financial burden and so lessens the impact of the sanctions that induce adherence to the required standard of care. Here, the relationship of the landlord and tenant does not have the monopolistic characteristics that have characterized some other relations with respect to which exculpatory clauses have been held invalid because there are thousands of landlords competing with one another in a rental market of competing types of housing accommodations. Conclusion. Therefore, the exculpatory clause is not unenforceable for violating public policy.